wrapped his hands in cloth, getting ready for battle with pins in them.
I could have gouged out his eyeballs. I didn't do that.
The defendant is refusing to rise, for the record. Are we ready to proceed? In this cause number 23, CR 727, the state of Texas versus Raymond Peoples, asking bailiffs to bring the defendant in, and then we'll bring the jury in. Make sure the jury doesn't come in yet.
Hey.
Yeah, we don't want to see he's being escorted. My mother said there would be days like this.
Clairvoyant, we need to talk to her about the lottery number.
Man, it is so hot out there. You know what they did? They turned on the spindle top spray.
Oh,
I gave Lamar, Marcy and I gave Lamar the gift of the original, one of the original photographs of the spindle top blow on the day it happened. It's it's one that's has only been published one time 125 years ago. And it was in an auction, and Marcy and I bought it and we gave it to Lamar. It's great to have it here in Southeast Texas. They're going to put it at the museum, Spindle Top Museum. You know why they call it Spindle Top? Because the trees around where the oil field they were drilling in, the trees were above on hills, and the trees looked like spindles in their leaves, and they called it spindle at the top, and it turned into Spindle Top, and that's the way that geyser ended up being named that way. I thought it was like a machinery part or something. Okay, Mr. Peoples, just sit up here. We'll put you right back where you were. We'll pick up where we left off. We'll bring the jury in. And the jury is seated in the courtroom. All parties are present. When we rested last, the defense was making his statement in his case in chief. You may pick up, sir.
Never caused no problems. Isolate, not this time, but the time where 3 years ago when they charged me with this charge, right? Never caused no problems in isolation. So all the CO would let me go to the day room in the cage and run. The videos, the pictures that y'all seen, where they took me and put me in a wrap, that's the day room. They can take the cuffs off you and let you work on the computer, talk on the phone, watch the TV, take a shower, right? In isolation, your movement is very limited and whatnot. But I would refuse to go back to the run because it was too many people playing with weights, too many officers that on a regular basis that like to take my paperwork. It happened actually 2 times. So after the second time, I wouldn't go back to the run. I just go to the run to go to the day room. So when I passed by that cell the night before Ford came to have fun with me, when I passed by that cell, I seen dude, it was streaks of his waist smeared on the window, and he even had it on his body. When I came back, he was still in there. After my hour day room, they put me in back in my cell, cell 6. A couple of hours later, he got moved to infirmary ISO. Nobody ever came from that cell. I was up practically all night. Nobody ever came from that cell. That morning, when Ford came up, it was around 7 or 8 o'clock. I'm letting them know that I just need somebody to clean this up because they moved that dude last night. I need somebody to clean this up. All he kept saying is it's already been cleaned. It was clean last night. I say, no, it wasn't. No, it wasn't. Can you please have somebody clean it up? It wasn't. He insisted that it was clean last night. He telling the other officers. Even Stevens, I'm telling Stevens, bro, can you please just go clean the cell up, man? He said it was already cleaned out, man. We just need you to go in there. When I told Darby just actually finally decided to go down there himself and look check. When he got back, he said, yeah, I see what you're talking about, man. But listen, once you get in there, I'm gonna I'm gonna give you chemicals. Once you get in there, we take stuff, I'm gonna make you chemicals and I say, nah. Last time he wouldn't let Levine give me that stuff. I don't trust him to do that. Just listen. When he walk out, just go down there, sleep down there, and throw it in the cell for him. Just throw it in the cell. He said, look, come on, man, stop giving us a hard time, man. No. Why is y'all thinking that it's okay? It's not okay. Now, all 3 of those officers sat in his chair and told y'all the same. They all told y'all that I was complaining about this cell being nasty and wanted it to clean up at that very moment, which means everybody had knowledge of my contentions about moving in that cell without it being clean, right? So that was a simple fix. Throw it in there in the mop, in a rag or something, and I'll do it myself. He wouldn't even let them do that. And they kept trying to make excuses for me to just chill and do what he telling me. Now, if everybody had that knowledge, why is they only taking pictures of isolation cell 6? Okay, everybody know I'm at cell 6. Why do you need pictures for isolation cell 6? Why are you not taking pictures of isolation cell 1? Why is everybody hiding the evidence of them trying to indirectly kill me and trying to make it seem like I'm some type of thrown off, chaotic person? I haven't done nothing to nobody in this jail for them to be doing it, which means somebody got to be sending it. I'm talking about one after another. Where this come from? I ain't never had no problems with Tinker. Why he did that? Yesterday, when I got back to the jail from this court, I've been, like I said, this is my 4th trial. I've been came to hearings plenty of time. They ain't never searched me coming back from court. They'll search me going to court, and they never search me coming back from court because there's no need to, right? Like, yeah, when I get back from court, Lieutenant Davalos and Sergeant Hawkins made me strip out butt naked, squat and cough while the cameras was going. And they stood a distance so the camera can see my whole body. I'm asking them, what is this? This to make me, what? So somebody told y'all to record this so they can have some fun afterwards? Why y'all got y'all recorders on? Y'all ain't never made a person strip out while recording. And why is it taking a rank to do this? The officer, I ain't never been searched by no ranking officer. It's always a regular CO that'll strip search me. Why is it 2 ranking officers with their cameras on, standing just 3 feet away from me, enough for it to see my body? They got their heads turned like they don't want to see me. Somebody had to send them to do that right after I left court yesterday, humiliating me. For what? Because Ford told them to? Because Ford admitted that I didn't stab him? Because they know the jury gonna find me guilty regardless, no matter what I say, and it won't add up? Yes.
Please get to the end, sir. Thank you. And again, stay within the 4 corners of the allegations. I've said that. That's what we're here for. Whether or not you have committed this crime of the 1st degree. Let me complete my sentence, please. She's counted up how many times you have interrupted the court during this hearing, and it's numerous times. Let me speak, and you have a fair opportunity to be heard. Stay within the 4 corners. That's what's relevant. 4 corners of the accusation. Thank you for following the rule. Go ahead.
So, right now, but this case, November 15th, sent the habeas corpus to the court, November 15th. It was filed in December or whatnot. The habeas corpus was explaining how Lieutenant Ford's statement admitted that I didn't stab him. And I also explained why I was combative, which made that charge completely illegal, right? In America, right? In this country, when an indictment isn't in the 4 corners of the allegation, right? That is, there we go. There's grounds for dismissal and to produce the body. That was like 10 months ago when I filed this, right? They wouldn't even give me a hearing for it, right? The hate corpus is that thing that Donald Trump wants so much to abolish because of situations like this.
No, I'm sorry, sir. You're misleading the jury. Habeas corpus, he is getting his time at trial. He wants his time at trial under the Constitution. That is his habeas corpus hearing right here, essentially, but with you and the jury. It was indicted. I don't make the decision on indictments. He didn't come to the judge for the determination of guilt or innocence. He has insisted on a jury trial, and with this being the 617th jury trial, we're trying as much as we can, as fast as we can, ladies and gentlemen. But under the law, this is what equivocates to a habeas corpus proceeding. This is the trial by jury. He has been insisting. He has it, and that is irrelevant. You can move forward. This is your time to be heard, sir. So I'm allowing that in spite of the difficulties here. Please proceed and move forward. Thank you.
Your Honor, I would like you to issue the writ of my habeas corpus, my previous corpus for this charge.
That is denied because it is not presented in the correct way under law. That's why I've asked you, please work with an attorney. If they help you do it correctly. Then when you insist on representing yourself, you have to follow the rules like all others. And the court is the person who makes the rule like a basketball official on the court.
Article 1148, written issue not necessary. It shall not be necessary on the trial of any cause arising under the habeas corpus to make up a written issue, though it may be done by the applicant for the writ. He may accept to the sufficiency of or controvert the return or any part thereof or allege any new matter.
Okay.
In the voice.
Sir, I'm going to present the law that's necessary for the deliberations. Corpus did not substitute for a trial by jury, ladies and gentlemen. This is what he has asked for. He's getting the trial by jury. An application for a writ and a writ hearing is a separate, completely different sort of circumstances. This is what the Constitution allows, a trial by jury, and we've got him here as soon as we were able to get him in the queue with our trial backlog that we have in this county. But we can only try one at a time.
All persons innocent until proved guilty.
No, sir, that's incorrect. The jury knows that.
All persons are innocent unless.
There you go.
proven guilty.
Good for you.
Right. So at my probation hearing, when you said based on the scientific.
No, sir, we're not getting into the probation hearing, sir. I'm sorry.
The 20 years.
Right. That you keep interrupting the court, you will be placed outside. We're going to have right now, the jury is going to be excused. This is a trial about the allegations of this indictment, and you have to stay within the allegations of the indictment, sir. We're not going to torque off on things that are not relevant to this trial, sir. And also, I have instructed you about interrupting the court so I can make a ruling with the court reporter. When you keep interrupting, I am unable to do my job. I've asked you not to do that. You keep continuing to do that.
I was talking about.
You were speaking about something that had nothing to do with this trial, sir. The next time you interrupt, you will be placed in a holding cell. We will have the trial for you to listen to. That's the way the rules say it happens when you keep interfering with the rules of decorum. Do you understand what will happen? Please follow those rules, Mr. Peebles. I want you to get what you want said. But if you keep interrupting and not following the rules, I don't have any choice but to change the circumstances. And you are the only one in this room who keeps not following the rules. Please follow the rules, and you have a chance to be heard and stay relevant to the allegations in this indictment. Do you understand, sir? We're in short recess.
Continue.
No, that's denied. We're going to complete this trial. Is going to make some findings here that the defendant is intentionally prolonging these proceedings by refusing to follow the instructions of the court, by bringing forth statements and thoughts from matters that are irrelevant to the four corners of this indictment. He has been instructed numerous times to follow the rules. He continues to disobey the rules. He continues most often to interrupt the court when the court is making its rulings and findings on the record, which prevents this court from doing its job. And I've warned the defendant, if he keeps that up, we have no choice but to put him in a different room where he can listen and watch the proceedings without interrupting them. We'll see what happens. But this has been consistent in this trial and railing on about matters that have nothing to do with the four corners of the charge is obviously an attempt to prevent this trial from ever ending. The court has a duty to move forward on a trial in an expedient way that's fair to all, and he's preventing that from occurring. All right, let's bring him out.
I got this one taken care of, and just stop. I did after the last 30 minutes, I got more done in 30 minutes than I have in all day.
All right, let's get the jury in, please. Thank you, Cal. Do not speak except to answer the questions while the jury is here. Don't be making statements in front of the jury, sir, that aren't part of the question and answers. The jury is seated. Thank you, ladies and gentlemen, for your attention and your patience. All right, Mr. Peebles, you may go forward. Be mindful of staying within the relevancy of the four corners of this indictment as it is alleged. Thank you. You may proceed.
24, I was cussing him out one day. He said to me, you must love living church. I said, no, I'd rather die on my feet than to live on my back. So he tell me like that statement is so that's because you used to doing people like me the way you do like that means nothing. I told him it means a lot to my kids, and I'm gonna make sure my kids understand to always fight for what you love. That's what I told him. I said, man, I would not be a good role model if I gave up on my kids. So you know what he had started doing? He started having people blocking access to the courts. June 25th, 25, I had wrote a federal judge about allowing Judge Steve to keep me in prison in violation of the habeas corpus proceeding. 3 weeks later, he had me bench out here 12 months ago. 3 weeks later, he had me benchmark out here, threw me directly into an isolation cell, blocked my communication. But in the whole time, Lieutenant Ford would cut my water on periodically, and I would have to argue and trip out about it just to get it cut back on. That complaint was judged for him refusing to rule on my habeas corpus.
Wait, hold on. So the jury is clear. Are you saying that I ordered sanctions against you in the jail? Is that what you're telling this jury? Is that what you're telling this jury, sir? Under oath.
I'm telling the jury that Lieutenant Ford is able to be doing the stuff that he's doing to me the past 12 months because I wrote a complaint on a federal judge for refusing to rule on my habeas corpus, which was complaining on you. And 2 days later, he ruled on it, but I was bench here. He ruled on it July 16, 2025. I was bench warrant out here July 18, 2025. But June is when I wrote a complaint that summed it off, which means it took about a week to get to the court, which means it only took 2 weeks for me to get bench warrant out here through an isolation cell after he denied my relief.
You're telling the jury that the judge denied the relief you were requesting, correct?
Right. And
Okay.
you've been out here.
All right.
That's the only way I can be bench out here. How did you know he denied my just 2 days before he benched? When I get out here, y'all put me directly in the isolation cell. TDC, I wasn't in the isolation cell. I had been in TD for like almost 2 years. But as soon as I filed a lawsuit a few months before and a complaint a few weeks before, I get benched out here and harassed at an extreme rate for 12 months by Lieutenant Ford and his co-conspirators. An appeal that August 6th, it was filed August 14th. In that appeal was my certificate of appealability. I had Sergeant Knott walk me to the office to call the court because I couldn't use my own phone. They were blocking. So he walked me to the lieutenant's office. They will only do that if you don't cause, if you're not a problem. So he walked me to the lieutenant's office and he let me call the court. I called the court and I asked them, did they get my certificate of appealability along with my, say no, all we got the notice of appeal review, but they know, which means all of that went in the same letter. It was in the same, so for my notice of appeal to only be, and then my certificate was identified on that notice, but my notice of appeal not filed. My certificate of appealability was identified on that notice of appeal. So for my certificate of appealability to not make it, will only have to mean somebody either took it out of my envelope before it got there, or the clerk had it in my file and throw it away. Sergeant Knott Cameron was going at the time when I called, and my anxiety went crazy. After that, they denied, they sent off a list, and I started giving my envelope directly to the COs, for them to give it directly to the mail agent to get off the unit, and write their name and the time and the date on the envelope, just to make sure it got off the system. When I sent my other certificate, They ended up denying it. Turned around, I sent the emergency motion for reconsideration. I called court on the 9th. The 9th of January. My certificate was denied on the 30th of December, which makes the deadline would have been the 14th of June. I called on the 9th to make sure they made it. And they said, I called on the 9th to make sure whether or not they ruled on my certificate. They said my certificate was denied on the 30th of December. So I sent off my motion for reconsideration on the 12th. When you're in prison or any institution, the day you file a motion, the day you put your motion in a penal institution, was still considered filed. But they told me I was on time because they ain't getting to the tomb. Throughout this country, in every state, the rule is the day the inmate places his motion in a penal institution mailing system, it is considered filed in the court. But they refuse to file it with the panel. For them to do that, a judge haven't allowed them to do that. So they wouldn't address the issue of this charge and all the other charges. So that with the Supreme Court will not file your habeas corpus if you don't do it right and if it is not in good faith. But yet they filed it. They died. And one of the justices denied it. I didn't know they reached this far. I thought I was safe in the Supreme Court. But the fact that I sent off an emergency petition for rehearing June 9th, and I'm sitting in this courtroom witnessing what just took place the past 2 days, especially at the jury selection, I know that it must be people in the Supreme Court allowing them to do this because they will not let me go to this trial. But then when I do get to the trial, they violate every right in the Constitution, every single right, especially the 6th Amendment. And I want everybody to know this. Even if you give me life in prison, that will not provoke me to hurt myself or nobody else. I'm gonna make sure my kids understand resilience, perseverance, integrity, dignity, honor, decor. It's very important. Never let nobody take that away from you. I'm done.
He has a right under the Constitution for cross-examination, sir. Did you want to ask any
I
questions?
don't need to talk to him.
Okay, you're excused. Anything else, Mr. You read? I take it from your silence, you're resting your case. Anything redirect from the state?
No, Your Honor.
All right, ladies and gentlemen, we're going to take a short break here. The court is going to finalize the jury instructions that we've been working on, and we can't finalize them until the parties have rested. And then we'll bring you in and go over the charge, and then the parties can make their final arguments to you, and you'll go into the. Thank you. That's our plan. Thank you. Everyone else remains seated.
Thank you, sir.
All right, the jury is exiting. The court has provided the parties with jury instructions. We're going to go over these. Mr. Peoples, make sure that these are in order. Members of the jury, introduction. The court will note that the defendant has pushed aside the jury instructions and is refusing to review them. And the court will also note that when I asked the defendant if he had completed his presentation of his case, he refused to answer. Then second is definitions page, then assault, aggravated assault with deadly weapon against a public servant, bodily injury, serious bodily injury, public servant definition, correctional facility, deadly weapon, intentionally, knowingly, jury charge, general instructions, 3 pages, 2 verdict forms. We, the jury, find the defendant guilty. We, the jury, find the defendant not guilty. The state, any.
There's an issue back when you got the definition of assault, and the next is assault on a public servant. That's not the correct definition of assault on a servant. Aggravated assault on a public servant. It's just an aggravated assault.
2B is section 20. It's under section 22.02 called aggravated assault.
No, it's under.
That's the way
It is, but it's.
That's the way it was indicted, folks.
It's not. No, but there's more to it than to be a public servant, not an aggravated assault. So you got it.
No, I know it's called but it's called aggravated assault. It's under section 22.02, which is aggravated assault. It's a form of aggravated assault.
I understand that, Judge, but you put aggravated assault of a public servant, and nowhere in that definition does it have public servant of a public servant in the performance of his duty, which is what it's supposed to have.
To
2A or B, 2B.
B2B.
Yes.
Under assault, aggravated assault with deadly weapon against a public servant. And I think this is the right definition here. A person commits the offense of aggravated assault. If he commits assault against a person the actor knows is a public servant lawfully discharging an official duty. A person commits the offense of aggravated assault if he commits assault against a person the actor knows is a public servant while lawfully discharging an official duty. What other changes?
No other changes.
Anything, Mr. Peebles, you want to change on these instructions?
Change the word.
I wish I could change the world, what his statement is. All right. Please make this change. Otherwise, any other objections by the parties?
No, Your Honor.
All right. We'll make this change, bring the jury back and read the charge, and then the parties can make the final arguments. Record shall now show that all parties are present and the jury is present. Anything to bring up further by the party, state,
No.
and Mr. Peebles on defense? Anything further? There's no answer. Earlier I asked and Mr. Peebles said, I wish I could change the world. So I'm going to move forward here. And at this time, the court will read to you the jury charge of the court, which contains the law applicable to this case. Ladies and gentlemen, in continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will, when I read this charge to you. It will be left with you to refer to as necessary during your deliberations, ladies and gentlemen. Members of the jury, the defendant stands charged by indictment with the offense of aggravated assault against a public servant alleged to have been committed in Jefferson County, Texas, on or about June 6, 2023. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. Definitions. So that you can better understand some of the words and terms used in the charge, the law provides the following definitions. Assault. A person commits the offense of assault if he intentionally or knowingly or recklessly causes bodily injury to another. Aggravated assault with deadly weapon against a public servant. A person commits the offense of aggravated assault if he commits assault against a person the actor knows is a public servant while lawfully discharging an official duty. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Public servant. Public servant means a person elected, selected, appointed, employed, or otherwise designated as an officer, employee, or agent of the government, even if he has not yet qualified for office or assumed his or her duties. Correctional facility. Correctional facility means a place designated by law for the confinement of a person arrested for, charged with, or convicted of a criminal offense. The term includes a confinement facility operated by the Texas Department of Criminal Justice. Deadly weapon. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Recklessly. A person acts recklessly or is reckless with respect to a result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the defendant's standpoint. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about June 6, 2023, the defendant Raymond Peoples did then and there intentionally, knowingly, or recklessly cause bodily injury to Charles Ford by striking Charles Ford about the head or body with pens, and the defendant did then and there use or exhibit a deadly weapon, namely pens, that in the manner of its use or intended use is capable of causing serious bodily injury or death during the commission of said assault. And the defendant did then and there know that the said Charles Ford was a public servant, namely a Jefferson County Corrections officer in the lawful discharge of an official duty, to wit, transporting said defendant with the correctional facility. You shall find the defendant guilty of the offense of aggravated assault against public servant. Stand by. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are in this case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. And it is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror nor consider it themselves and arriving at a verdict. Questions and comments of the attorneys or parties, if they represent themselves, do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys or the defendant representing himself that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson, and then be given to the bailiff. The question will then be answered by the court as soon as possible, to the extent allowed by the law. Any physical exhibits which have been admitted into evidence will be furnished to you by the bailiff upon your request. After the attorneys and the defendant present their arguments to you, you will retire, Select a foreperson and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision or decisions, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. There are two options you have. One, we, the jury, find the defendant guilty of the offense of aggravated assault against public servant as charged in the indictment, placed for the foreperson to sign. Your other option, we, the jury, find the defendant not guilty of the offense of aggravated assault against public servant as charged in the indictment, a place for the foreperson to sign. Of course, only one jury form can be signed. Under the rules, the state of Texas may open and close final arguments. What says the state?
State of waive its right to open, reserve its right to close, Your Honor.
Okay, the state has waived its opening. Mr. Peebles, you can move forward and give your final argument now.
During the video, during examination of the video yesterday, you all seen and witnessed that when I exited the cell, I never swung or struck anybody with those pins. Even more so, Sergeant Anderson blatantly said I struck Lieutenant Ford with the pins after Lieutenant Ford admitted that his injury came from my fingernail. You also heard the testimony of everybody that say they don't remember seeing me strike Lieutenant Ford at all with the pins. 5 people was there. Only one person said that. 4 people is not gonna mistakenly miss something so explicit, especially the way it was strapped to my hand. Clearly, I was doing what I was doing to deter his actions and discourage the constant harassment. Clearly, that didn't work. So, being that didn't work, I obviously had no intentions on stabbing him. When I grabbed his face, I could have gouged out his eyeballs. I didn't do that. Clearly, my intentions wasn't malicious. I just simply wanted the cell clean, which by law, that's cruel and unusual punishment to force somebody amongst something like that. But yet, everybody in exhibit 1, 2, no, I forgot which one it was. But after I showed, what's his name, Detective Gardner, his report, he said he did write this or whatnot. And one of the papers is he stated in his report, Lieutenant Ford indicated in his report that Peoples exited the cell holding a pen in each, and holding the ink pen in a manner to use as a deadly weapon, but he believed the visible injuries he received come from Peoples' fingernail. His aggression was focused on Lieutenant Ford as he used the ink pens to cause several lacerations on Lieutenant Ford's face, neck, and upper chest. Several of the wounds were close to Lieutenant Ford's right eye and could have resulted in more serious bodily injury. So regardless of how they manipulate the law on the instructions, the indictment is clearly stating that I stabbed him. His probable cause affidavit is clearly stating that I stabbed him. His report explicitly demonstrates that I stabbed him. The indictment expressed that I threatened with imminent bodily injury, which would be force of a violent nature, right? Which would be assault, not aggravated assault. Aggravated it becomes aggravated when you use a weapon, simple as that, or cause serious bodily injury, one of the two. Use, not just exhibit a weapon, not just hold a weapon. When you exhibiting that weapon, you have to actually use it, which means if you have a knife in your hand and you cut somebody, that's using it. If you have a gun in your hand and you shoot somebody, that's exhibiting it while causing serious bodily injury if that bullet hits them. Exhibiting it is merely a description of a remote a remote injury. That's it. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the actor purpose is limited to creating the apprehension that he will use force if necessary, does not constitute deadly force, which would be aggravated assault. Penal Code 9.04, Texas Penal Code 9.04 is what that
Sorry, I'm
was.
gonna have to, he's stating law that's not in the charge and is not before the jury.
All right, the objection is sustained. Ladies and gentlemen, you can only consider what is within the jury charge and the law that the court has given to you. That is what the law states. It's in the judge's domain, the law to be given to you based upon the law. The parties are not allowed to supplement the law during final arguments or to change indictments or to change the laws. So your objection is sustained. Move forward, sir. Thank you.
A person commits an offense if he recklessly engages in conduct that places another in imminent danger of serious bodily injury. The production, reckless and danger are presumed if the actor knowingly pointed a firearm in the direction of another or not. Actor know or not. That's what I have 20 years for.
I'm sorry. Once again, if two people speak over each other, when an objection is made, Mr. People, you have to stop. You will have an opportunity to complete what you need to say for the record. The objection is sustained. Did you want to add anything else, sir?
Yes.
Okay.
So I want you guys to be aware that the day that the judge violated my probation, he gave me 20 years for the aggravated sexual assaults or whatnot. And then I went to trial afterwards and found and it was found not guilty.
Hold on. Yeah,
I want you to understand
Sir,
that
hold
was
on.
double jeopardy.
hold on, sir. Hold on, sir. So the jury understands this court doesn't violate anybody's. I'm not violating anybody's probation. If someone is on probation, a motion to revoke is filed by the executive branch of government. It's not a jury trial. A motion to revoke probation gets heard strictly, exclusively by the judge, and the judge makes its determination based upon whether it's a preponderance of the evidence standard or beyond a reasonable doubt based upon the circumstances. But just so that you understand, so that you're not confused, this court doesn't violate anyone. And in the way that term is used properly in English. But if someone is on probation and violates probation and there's a hearing and the court finds that enough hearing supports the allegation of violation, then the court can grant the motion to revoke probation, then find the defendant guilty, and then the court has the authority to set a sentence based upon additional information that the court may receive for sentencing. That is the way that works. But once again, just so that you don't, so that you're not misunderstanding, this court doesn't violate a human being. I don't violate people. That's misuse, and I don't want you to misunderstand. But a person on probation, if they violate the terms of probation, not me, but if a defendant does, by proof, then the court can revoke probation and sentence a defendant. That's the way that works in motions and revocations of probation. This is not a revocation of probation here. This is an indictment separately alleging what you've heard throughout this case and what was read to you and what the court instructed you on under its instructions. All right, Mr. Peoples, you may go forward.
And yes, the judge is right. A court may violate a person if they're on probation or whatnot, if they have jurisdiction of that charge that they're violating that person on. But if they never had jurisdiction in the first place and that charge wasn't supposed to be in their court, they was never allowed to violate. It wasn't sanctioned. That act wasn't sanctioned by law at all. Actually, that's an understatement. They never had any legal right, period. No power to violate that probation. Correct, Judge? Is that correct? Am I correct?
I believe the jury is making a determination on the indictment, sir.
Right.
The probation, any probations are not part of this case. Please strictly stand by what's been charged so that the jury is not confused. Thank you.
So
Let's stay with the indictment and the proof for this indictment. Thank you,
Alright.
sir.
on this indictment, they plan on giving me 15 years to life because of my prior conviction, which the judge never had authority to convict me on in the first place. Is that correct, Your Honor?
You're asking me a question, sir?
Yes.
No, move forward. This court has not been reversed in your cases. No. The decisions made in your cases have been final and approved and affirmed. Move forward
But
with this argument. Thank you,
I
sir.
was asking, was my interpretation of the indictment that I have now?
We're talking about the indictment. There is a presumption of innocence, and I wrote the lead article in the state and law on the presumption. That's sacred. The presumption of his innocence exists unless the jury decides proof has been proven beyond a reasonable doubt otherwise. That's the rule of law. Go forward. Thank you.
With two of those charges being one being dismissed and the other one being found not guilty, I will be being held without indictment, right? The fact that I'm doing 20 years in prison for those violations, for those sexual assaults, will mean I will be getting held without indictment, seeing that two of them don't exist anymore, correct?
I'm going to object. If Mr. People stick to arguing this case, he can do his appellate work with the appellate court, which he's already done.
All right. So,
Those rulings have already been sustained by appellate courts. Let's move forward on this case. Thank you.
all right. Witness against, right? Anytime a witness themselves, the witness themselves, right? Not a prospective witness, but the witness themselves, the victim, admits to the contrary of the indictment. I mean, the Sixth Amendment would be getting violated when it says the accused shall be confronted by the witnesses against him. So if the court says that the jury is bound by the law, right? You know, for the love of God, right? By law, I'm not supposed to be convicted of this crime. Correct, Judge? Or did I
You don't
miss?
ask the court questions during final argument. You know that, sir.
Oh,
Make your final argument.
I just thought you were going to
Thank you,
interject.
sir.
So the implements for an escape. The fact that the detective himself wrote that on one of his reports that the victim believes that he was scratched. And then on the other one, he admitting that I told him I had no intent, nor do he have any evidence of any intent to escape, right? It makes that those two factors also makes both of these indictments illegal. So, you know, that's pretty much all I got to say about this. And also the law says whoever knowingly have knowledge, whatever officer knowingly have knowledge of the illegal confinement of the person that they have detained shall issue the writ without delay. Code of Criminal Procedures 11.15. And it is his duty to issue the writ without delay. That's 11.05. Code of Criminal Procedures 2.03. The state, the prosecutor, the judge, and the attorney representing the defendant, what are all attorneys, all court officers, shall conduct themselves to seek justice, not impair the ability of the accused to prove his innocence. 2.03 Code of Criminal Procedures. I'm done.
Statement closed.
Patience this last few days. I hope you could appreciate the tightrope I've been walking, trying not to overdo that lawyer stuff and trying to help Mr. Peoples when I can. But there comes a time when we got to look and say, you know, all this stuff that he's been doing, he's already done in appellate courts and everything else, and they've all denied him. And so he doesn't get his way. And so he keeps saying it over and over, just like he did with the lieutenant, hoping he'll get a tray. And I get tired of it because what he did that day on June 6th of 2023 was a violent act. And you cannot deny that, because if you deny it, then you have to say, I don't recognize the fact that he wrapped his hands in cloth, getting ready for battle with pins in them, and came out of that cell with his mattress out in front of him. Why did he wrap his hands with cloth and put pins in them? And why was he coming out of the cell with those if he wasn't intending to harm anyone? Second, you heard Lieutenant Ford say in his testimony that when Mr. Peoples reached for his face, lunged at him, which you've heard a couple of them say, lunged at him with his hands, he still had those pins in his hands and all he felt was pain. And yes, there's some scratches on there, but you also see that little sharp one. And that's where Arliss Anderson saw, standing right next to where Lieutenant Ford was struggling with this man, who all he had to do was say, I'll go down to the other cell. And he had a chance with Mr. Darby up here on the stand. You remember Mr. Darby walked all the way down to that cell and stuck his head in there, was in there for 30, 40 seconds looking around. And he did not come back and say, yeah, you're right. Because he could have asked him that while he was on the stand, and none of that ever happened. Darby said he went down there and looked, and the cell was fine. And all the officers went down there with him afterwards and said the cell was fine. So all that stuff he's doing is just a smoke screen, just like it was for that when he threw himself on the ground because he didn't get a tray. He doesn't get his way. And so he starts just doing anything he can to try to get his way. It's all about Mr. Peoples. Everybody's out to get Mr. Peoples. The appellate court's out to get Mr. Peoples. The judge is out to get Mr. Peoples. I'm out to get Mr. Peoples. I even have some influence with the Supreme Court of the United States and the Court of Criminal Appeals. I don't know where that comes from because I've never even been to the Supreme Court or the Court of Criminal Appeals, but that everything will have influence there. I've wrongfully indicted him, wrongfully convicted him. He's doing 20 years in prison for something that he shouldn't have done. And he won't even accept responsibility for that, even though he knows he pled guilty to it. And we'll cover that later. But he can't just say things. He can't just come up here and say things because everybody in that whole unit said that he came out with those pins and was flailing them around. They didn't see who he hit. A couple of them didn't see it, but Arliss Anderson saw it. Lieutenant Ford saw it coming at his face. And those pins were there. The wrapping was there. Everything's there that said happened. And you don't have to agree. You need to know that under this law. And you can look at the law. You do not have to agree on whether you think he did it intentionally, or knowingly, or recklessly. Some of you can think he did it intentionally. Some of you can think he did it knowingly, knowing he might cause injuries. And some of you can think he did it recklessly by the fact that he did it, because all that is an aggravated assault and it's against a public servant who's doing a lawful duty. That cell was being decommissioned. You've heard them all say it. They have to follow certain standards. They were decommissioning that cell. They had to do some work on it to make it safe for them. And then you get back to why do you have to do stuff on cells? Because even introduced it in here. People get out of their cells to attempt to escape. This man did. He introduced it himself. His cell, plugged up the cell lock and walked out and was wandering around. They caught him in a trustee uniform, walking around with a blanket where he could get out. All that's the stuff he was introducing. So y'all need to think about this. This man does not tell the truth. He gets up here and lies. He lies to them about the trace. He lies to them about the phone calls. He lies to you about the law. He's just doing anything he can to get his way. Don't give him his way. Don't reward him for being the person that he is. These people that have to protect you while they're watching people in jail, prisons, they have enough to put up with just dealing with the day-to-day stuff and making sure that everybody's safe and everybody gets what they want. But then they have to deal with people like Mr. Peoples. This gentleman over here does nothing but cause them misery, heartache. You heard them. They all have dealt with him. Even Lieutenant Tinker, bless his heart, you can see him trying to be nice and just come on down and get in your cell. And what's he doing? Grabbing the cell, holding on, arguing, and then he starts yelling those words. And I want y'all to remember those words he was yelling from inside that cell. I'm going to kill. Now, I'm not going to repeat the N word that he used.
Well, don't.
That was being yelled out by this man in that cell. Why would you yell that out over a stupid tray that came from Tuesday on a Sunday, and you don't get your Tuesday tray on Sunday? They don't do that. And the lieutenant ended up giving in to him and giving him a tray. It just rewards him. So I'm asking you, when you go back here, you look at this, it's apparent from the injuries on Lieutenant Ford, and I'm not going to harp on them, but you do need to remember why we're here. We're not here because he didn't get to go get his way. We're here that right there is not from a fingernail. This right here is not from a fingernail. Those are sharp instruments coming down, and it didn't come down because he was trying to distract him. He was trying to get him in the eye, guys.
trying to poke him in the eye and he missed. That's why it came down here and it's down here all the way down because he was swinging. So don't feel sorry for him. You should feel sorry for Lieutenant Ford who has to go through that every day with this man. Don't reward him for being the way he is. That is not what you do with people who throw fits and try to hurt people in jails that are just trying to make sure everybody's safe, including the people outside the jail. If they're trying to get out, they're trying to harm people in the jail. Do you really think those guys, that this is that important, that all those people would take time out, even people that left, if this man didn't do something that serious? Why did they come up here? And Lieutenant Ford, if you want to think he's a liar, wouldn't it have been easier for Lieutenant Ford to say, hey, I saw him stab me in the eye. He was trying to get me. I saw him swing at me several times. Wouldn't that make more sense if he was trying to lie about this instead of I saw his hands coming at me and then I felt pain and I don't know, fingernails or what? Arliss Anderson, who doesn't have anything against him. You didn't hear one thing about Arliss Anderson causing him any problems anywhere else. Comes in here and says, I saw him do it. And then, if you want to know what kind of person he is, just look at all the stuff he even admits to. Throwing stuff on people. Totally causing havoc in that jail. He needs to be put back in prison so they don't have to deal with him. We don't have to deal with him. He needs to go away. But right now, all we need to do first is talk about finding him guilty. Hold him responsible. Don't listen to his wanderings and meanderings. Hold him responsible for what he did that day. Then you can talk about punishment later on. You can adjust it however you think it is. But don't let him just walk away from this. You know what that does? That tells him, you know what? Go do it again. Throw all the fits you want, do what you want, then come in here and just go, oh, they're all against me, and everybody just let him go. Go ahead, let him go. If you want him to do this again and just keep on doing this, let him go. Feel sorry for him. Or you can say, you know what, enough's enough. You don't rule this world. You don't get to rule the jail. You don't get to rule this day, and you don't get to rule this court. No matter how hard you try, hold him responsible, find him guilty, and then let's get on to the next part, and you can do what you need to do there. Thank you.
All right, ladies and gentlemen of the jury, this time I'm tendering the jury charge to the bailiff. I'm going to ask you, please step down from the jury, follow the bailiff into the deliberation room. We will await your verdict. By rule of law, only 12 people are allowed in the jury room by law. That means the alternates have to stand out, hold vigil, don't stand up, go outside, relax, stretch your legs. We've had to replace jurors during deliberations before. That's why by law we keep you until the end. But thank you. And you never know, we may be able to pull you into the game here before the end. Thank you for bearing with us. All right, we now recall cause number 23, CR 727, the state of Texas versus Raymond Peoples. The defendant is present. The state's representatives are present. Have the parties had an opportunity to review the jury charge here for this punishment phase? And are there any corrections or changes to it? First, state.
Nothing for the state judge.
And Mr. Peoples, any changes?
I don't care about it. Y'all do, just get it over with.
All right, bring the jury in then. Show that the jury is seated in the courtroom. Ladies and gentlemen of the jury, this time I'm going to read you the jury charge for the punishment phase of this trial. And again, please continue to observe the instructions previously given to you. As before, this charge will be left with the jury and your foreperson, so you can refer to as necessary during your deliberations. Members of the jury, you have found the defendant guilty of the offense of aggravated assault against public servant as alleged in paragraph 1 of the indictment. Paragraph 2 of the indictment further alleges that the defendant was previously convicted on or about April 22nd, 2021 in cause number 16-24808 for the offense of aggravated assault in the Criminal District Court of Jefferson County, Texas, and that this conviction had become final prior to the commission of the offense for which you have now found him guilty as indicted, the first-degree felony of aggravated assault against public servant. To this allegation in paragraph 2, the defendant has entered a plea of untrue. It now becomes your duty to determine if these allegations are true or untrue, and to set the punishment in accordance with the law. if you believe from the evidence beyond a reasonable doubt that the allegation in paragraph 2 is true, you should so state in your verdict and assess punishment for the commission of an enhanced first-degree felony. If you do not so believe, or if you have a reasonable doubt thereof, you should find the allegation in paragraph 2 untrue, and so state in your verdict, and thus assess punishment for the commission of a first-degree felony punishment. Our law provides that an individual adjudged guilty of a first-degree felony shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice, in other words, prison, for life, or any term of years not more than 99 years or less than 5 years. In addition to imprisonment, an individual adjudged guilty of a felony of the first degree may be punished by a fine not to exceed $10,000. Enhanced first-degree felony punishment. Again, this would apply if you deemed that the prior conviction was proven true to your satisfaction. Our law provides that an individual adjudged guilty of a first-degree felony who has previously been convicted of a felony, and this would be a felony above a state jail felony, shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice prison for life, or for any term of years not more than 99 years or less than 15 years. In addition to imprisonment, an individual adjudged guilty of an enhanced first-degree felony may be punished by a fine not to exceed $10,000. You see the difference between these two? If it is not enhanced by a prior conviction, it's 5 to 99 or life with a fine. If it is, it's 15 to 99 or life for imprisonment, and then $10,000, up to $10,000 in fine. Good time credit and parole. Under the law applicable in these cases, the defendant, if sentenced to a term of imprisonment, may earn time off the period of incarceration imposed through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignment, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. It is also possible that the length of time for which the defendant will be in prison might be reduced by the award of parole. Under the law applicable in these cases, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less, without any consideration of any good conduct time he may earn. If the defendant is sentenced to a term, and this is not going to apply in this, but it's the law and we've got to go through with it. If the defendant is sentenced to a term of less than 4 years, he must serve at least 2 years before he is eligible for parole. And once again, that is not applicable under this set of circumstances because the minimum is higher than 4 years. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to the defendant if he's sentenced to a term of imprisonment, because the application of these laws will depend upon decisions made by prison and parole authorities. Now, you may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. And you are not to consider the manner in which the parole law may be applied to this particular defendant. Of course, that's because those decisions are made by other authorities. General instructions. The attached verdict forms are supplied for your use. When you have reached your verdict, your foreperson should fill in the appropriate form and sign their name as foreperson. In arriving at your verdict, it is not proper to fix the punishment you assess by any system of averaging. Your verdict must be determined only by a full, fair, and free exercise of the opinions of each juror based upon the evidence presented. Your verdict, as before, must be unanimous. Your failure to follow the law contained in this charge could result in a mistrial being declared, and your deliberate violation of these instructions could result in your being held in contempt of court. Okay, we have two sets of jury instructions And each of them have 4 options to review and determine which is applicable based upon your decision on the prior conviction, whether that's been proved or not. The first set, and this is if you believe that the prior conviction has been proven. First option is we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice. I will refer to that as prison from here on, for a term of blank years. And that would be no less than 15 nor more than 99, a place for the foreperson to sign. The second option of this bundle of 4, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense, that is something above of a state jail, 3rd or higher, as alleged in the indictment, and assess his punishment at confinement in prison for a term of years, no less than 15, no more than 99. In addition to such imprisonment, we assess a term of blank dollars not to exceed $10,000. Third option, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in prison for life. And the final 4th option, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in prison for life. In addition to such imprisonment, we assess a fine of up to $10,000. Only one option of the 4 on either set can be signed. Does everybody understand your 4 options here? And the next set are based upon whether, if you believe that the state has not proven beyond a reasonable doubt that the defendant was previously convicted.
They haven't.
Sir, you just made an outburst. Again, an inappropriate outburst. Please don't do that again, sir. Thank you. These 4, again, we will go over them, ladies and gentlemen. The first option of these four, we, the jury, find the defendant has not been convicted of any previous felony offenses as alleged in the indictment, and assess his punishment at confinement in prison for a term of blank years, no less than 5 nor more than 99. Does everybody understand the distinction here? Place for the foreperson to sign. Second option, we, the jury, find that the defendant has not been convicted of any previous felony offenses as alleged in the indictment, and assess his punishment at confinement in prison for a term of blank years, no less than 5 no more than 99. In addition to such imprisonment, we assess a fine of not to exceed $10,000. Sees the difference there. A fine is applied on this one if that's your choice. The third option, we, the jury, find that the defendant has not been convicted of any previous felony offenses as alleged in the indictment, and assess his punishment at confinement in prison for life. And your final option, we, the jury, find the defendant has not been convicted of any previous felony offenses as alleged in the indictment, and assess his punishment at confinement in prison for life. In addition to such imprisonment, we assess a fine of blank. Only one verdict form can be signed out of these 8. Does everybody understand the distinctions? As before, the state of Texas may open and close final arguments. What says the state?
We'll waive our right to open the
You may, Mr. Key, you may present your argument to the jury.
Waive my right.
All right. You're doing that voluntarily and because that's what you want.
That's what I want.
Then the state may go forward.
I'll be brief since we don't have, we're after hours here. I think it's pretty obvious when you look, and you can even take these back with you if you want to. The allegation alleged in the indictment report, you can get a look at it, which is the actual, which was the actual conviction occurred before he committed this offense, and so makes it 15 to life. And that's what we're asking you for. And I think you need to, I feel really bad because whatever I ask you to do, I'm going to put you back. I'm going to put him back with those jailers. They have to put up with him. But he talks about the fact that, well, first of all, he says he does so well in prison that that's where he doesn't commit any other of these offenses. That he says he does well and he's out in free population. So you're actually doing him a favor of getting him out of isolation and putting him in prison. And I hate to say that, but because it is punishment. And I'm asking you this because I want you to think about this. First of all, he's right. He was placed on probation I'll just do it. He was placed on probation. And if you look at this, you'll see that back here on the signatures is not only the Raymond Peoples signature, but my signature. I gave him a chance. Back in 2016, I gave him a chance. I said, if you'll own up to this and you behave yourself, you can get out of this without a conviction. You get probation for 10 years. And if you're really good, you can get off probation without a conviction. He couldn't follow the rules. And that seems to be a pattern with Mr. Peoples. He doesn't want to follow rules. He wants to control everybody. That's what he wants to do.
Because you said.
Sir, I'm sorry, sir, you cannot make outbursts. You gave up your opportunity to make a final argument. He has a right under the law without interruption to make his final argument. So please follow the rules, sir.
He cannot follow rules. And the problem is with this is that it's kind of funny when he does it in here. But when he does it in a jail setting where there's weapons or he's got things that he can hurt people with, or where he throws feces on them or does things to them to just totally make everybody's life miserable. Plus he's got other inmates that he's throwing things on. He's trying to escape. He's doing all these different things. It's not funny. This time it's not so funny as because he's facing 15 to life and it's serious. And yet he's still here making all these comments because to him, it's just a game. Everything is a game. It's not about anything. It's all about people. So what I'm going to ask you to do is I'm going to ask you to make this sting because he was serving a 20-year sentence when he did this. And evidently that doesn't scare him one little bit to serve a 20-year sentence. He's asked you a while ago, he told you just go ahead and give me a life to send me home. And that's up to you. But I'm asking.
That's what it is. I'm telling.
I'm sorry, sir. The second time I've had to scold you on making outbursts during a time that he is not to be interrupted by law, just like you were not to be interrupted if you wanted to make your closing argument. Please follow the rules. Again, I state to you, please follow the rules.
And it makes me sad that an individual can't just do what he's asked to do. It's real simple. Just move here, do this, just remain quiet, follow the rules. But he has to be in control. And we talked about that in board hour. People have to be in control, and he's got to be control being his own lawyer. He's got to be in control in this courtroom by stopping and saying, and I let him have his free reign. Y'all saw that I did that. When he got up there and said, I let him have his say. I wanted him to have his say. I wanted him to be able to tell you everything he wanted to tell you because you realize who he is.
Because you had already.
Sir, this is the third time during the final argument you have interrupted the attorney. And again, do not do that.
So y'all go back there. You know that enhancement. So following your oath, you find it true. And the first 4 pages that you see of their verdicts is what you're going to be looking. And you're going to ask me to give you something. I'm just going to ask you to give him a really good bump up from 20 years because of the fact that he was serving 20 when he did this. And that doesn't seem to affect him. So he needs to get a little spanked a little bit harder to make sure that he understands that he's not in control. He's not in control.
For the record, that's the 4th time that the defendant has defied the court's order and has interrupted the prosecution who is giving his final closing, which the law says he can do without interruptions, unless you want to make a legal objection.
That was legal.
That was not, sir.
Objection. For point of done,
Proceed.
30 years to life.
Sir, your objection's overruled. Proceed.
See, the problem is you wake up every morning and you see violence out on the street. And so what do? We put them in jail. And we trust them to people that they come up here and they try to do their best to watch these people. And what does he do? He creates the violence in the jail. You can't seem to stop him from doing that. So there's only one place to go, and that is someplace where he's going to be controlled by some state people that will have more resources than our county jail to keep him there, to keep him under control. So I'm asking you to at least double what he got before, from 20 to 40, to make sure he knows that this is not the right thing to do, to treat people the way he treats people, and he's not in control. So thank you for your time.
And ladies and gentlemen of the jury, at this time, I'm tendering the jury charge to the bailiff. I ask you to please follow your 4-person into the jury deliberation room. We will await your verdicts. And alternates, thank you for hanging in there with us. Sir, you're going to have to muffle him. He can't be speaking to the jury as they're leaving like that. That's improper. That was the fifth time the court had to scold the defendant for making outbursts at closing during the state's closing. That is all. We're in recess. We're in recess.
What else can you do wrong? What else can you do? Keep your isolation for another 12 months?
He's gonna handle his own deal.
Is he?
Oh, yeah.
That's.
He's got like 3 writs pending here. I think he's got 2 pending. He's filed stuff with the Supreme Court. He's filed stuff with the Court of Criminal Appeals. They've all denied everything he's done, but he keeps filing.
Yeah.
They call him the serial filer. No, he calls and he goes, well, why would you know this people's play? First of all, he goes, well, the first 2, and then the second one's still pending, but
We all just go out and get coffee out. I second that. And I don't drink. Me neither, but I second that.
well, I'm gonna just watch other people drink.
Hey, that's what,
It's sad, because lots of them watching.
it was creative, was it?
All right, we have a verdict on the punishment phase. Stand by, please. Stand by. Thank you. We've received a verdict on the punishment phase of this trial, and we will bring the jury in to receive the verdict. Record shall show that the jury is seated in the courtroom. And Mr. Stanley, as foreperson of the jury, we've received a message on your behalf stating that the jury has reached a verdict in this punishment phase of this case involving Raymond Peoples and cause number 23 CR 727. Is all of that correct, sir?
Yes.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury?
Yes.
Any of the jurors disagree with your foreperson's representations? No disagreement is indicated, and it does indeed appear to be unanimous. As before, if you would pass the documents to the bailiff, I will review the proper form and publish the verdict. But you're only one assigned. You did that right. All right. The defendant shall rise. In cause number, the defendant is refusing to rise, for the record. In cause number 23 CR 727, the state of Texas versus Raymond Peoples, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years. Signed by the jury foreperson. The verdict is received and made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, your duty as jurors is completed. At the beginning of the trial, I placed each of you, releasing you from all those instructions previously given to you. However, one final instruction: once you are discharged, you are released from your oath of secrecy. Once you are released, you are free to discuss these matters as you choose and free not to. I want to thank you for your service as jurors. And it's the way the Constitution works. We, the people, get to make these decisions on other people's lives. And I think that is the proper way to do things. I hope to have the honor to work with you in the future. May God continue to bless Jefferson County and her citizens. And you are excused. Thank you. You are going to have documents.
If they'll wait for me out front, I'll have their excuse letters for work or school.
Okay. She'll be shortly. Thank you. Yes, ma'am. Stand by. Thank you, sir. Take care. In 23 CR 727, is there any legal reason why judgment shall not be formally assessed at this time? State or defense? No response from Mr. Peoples. Mr. Peoples, Raymond Peoples, you came before this court and a jury, entered a plea of not guilty to the offense as set out in the indictment. The evidence was submitted. The jury was charged by the court. After deliberating, the jury returned a verdict finding you guilty of the first-degree felony of aggravated assault against a public servant. Thereafter, evidence was presented on the punishment phase. The jury was instructed on the law on punishment during their deliberations. After deliberations, they assessed punishment at 40 years confinement in prison. It is therefore the judgment of this court that you are guilty in this cause number 23 CR 727, and you shall be punished in accordance with the jury's verdict. Is there any legal reason why sentence should not be pronounced against the defendant by either party?
No.
Finding nothing to bar the pronouncement of sentence against you, it is the order of the court that you, Raymond Peoples, who has been adjudged to be guilty of the offense of first-degree felony of aggravated assault against a public servant in this cause number 23 CR 727, and whose punishment has been assessed at 40 years confinement in prison in the Texas Department of Criminal Justice's Institutional Division, shall be delivered by the Sheriff of Jefferson County, Texas, to the Director of the Texas Department of Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 40 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. Stand by. Under Article 42.08 of the Texas Code of Criminal Procedure, the law states if a defendant is sentenced for an offense committed while the defendant was an inmate in the Texas Department of Criminal Justice and serving a sentence for an offense other than a state jail felony, and the defendant has not completed the sentence he was serving at the time of the offense, the judge shall order the sentence for the subsequent offense to commence immediately on the completion of the sentence of the original offense. What does the state say?
Judge, it's pretty clear that this person was, Mr. P was serving a 20-year sentence and was still under the custody of the Texas Department of Criminal Justice. So it's mandatory to be stacked. We'd have to stack it on top of this prior sentence in number 16-24808.
Your objection is made. It is overruled. The law is clear under Article 42.08. So you are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 40 years. And that sentence of 40 years shall commence immediately on the completion of the sentence for 3 years. You're going to have to stop him from speaking so we can complete this. As obstreperous as he'd been through the whole trial, he continues to interrupt the court. The judge, under the law, orders, and this is cause number 16-24808, that the court finds that the defendant was an inmate in the Texas Department of Criminal Justice serving a sentence for the offense of aggravated assault, a second-degree felony, convicted on April 22nd, 2021, in cause number 16-24808, in a conviction in this criminal district court of Jefferson County, Texas. He has not completed the sentence he was serving at the time of the offense that he has now been convicted, this first-degree felony of aggravated assault against a public servant as adjudged by the jury. Thus, the judge is ordered to sentence the defendant of this subsequent offense. He has now been found guilty in 727, which was committed subsequent to the conviction he received in cause number 16-24808 of the second-degree felony of aggravated assault. The judgment shall state that this offense here, the sentence in 23 CR 727 of 40 years confinement in prison, shall commence immediately on the completion of the sentence the defendant is serving in cause number 16-24808, the aggravated assault second-degree felony. And thus, this sentences shall run cumulative or consecutively to each other by law. The defendant will be given credit for all time he has served in accordance with these sentences. And that is the finding of the court, and that is the ruling. Anything else to add? State or defense? We're in recess. You are here. You are now remanded to the custody of the Sheriff of Jefferson County until she can obey and carry out the direction and instructions of this sentence. That is all. And please note that the defendant was shouting over the court as he is being led out, as the court is trying to read the formal sentencing and a judgment as provided by law. And again, throughout the trial, the defendant interrupted, refused to follow orders of the court so that the proper order of the proceedings could be made, his attempts throughout this trial to interrupt, and were allowed for the most part by the court, although the court would attempt to instruct him not to do that. That never stopped him to the very end as he continued to interrupt the court, and also his defiance to court rulings throughout this trial also were multiple, as it's obvious that the defendant was not about to follow the rule of law nor the orders of the court. The court attempted, though, to give him more leeway than the court has given to any other defendant out of the court's history of 616 jury trials in this courtroom. But nonetheless, the defendant to the very end acted obstreperous and defiant of the rulings and orders of the court, and interrupted throughout the proceedings. And this court even allowed him to make lengthy narrative statements during his presentation of the evidence, which were not in a question and answer method to a witness, but were his long narrative complaints about the processes that he was claiming to endure while being an inmate. All of that is clear in the record, and the court was attempted numerous times to allow the defendant chance after chance to correct himself. And to the very end, he continued to interrupt, defy court's rulings, respond in defiance to the court's rulings. And thus, this was a case that had a lot of interruptions to it. All right. And all due to Mr. Peebles' defiance to orders and rulings, and defiance to just decent standards of respect to other parties and to each of the participants in the trial. And we are now in recess. This the judgment's going to be stacked on top of each other.
Okay.
Okay. Anything else? Then we are in recess. Thank you.